Welcome to week 2 in legal issues and corrections. We're going to start by looking at part 1 of the textbook, which is the sources of corrections law. And specifically this week, we're going to look at chapter 1 and 2. Chapter 1 is an introduction to the law. Since the 60s, the law has had more of an impact on corrections than any other factor of force, and that's why we're going to spend a lot of time on it. Court rulings have directly impacted corrections. In terms of management decisions, it was initially seen as an intrusion, but now court decisions are eventually more accepted. It's accepted more than new programs, more than research, studies, developments, rehabilitation efforts, different crime theories, even technology. There's a lot of reliance on court rulings these days. Take a look at how the chapter is outlined. It takes a look at how the textbook is actually organized, the law, the historical origins of law, the branches of government, the court system, both at the federal and state level. And it's going to define criminal and civil law and then differentiate between the two. Part 1 of the textbook is actually chapters 1 through 4. We'll start out by looking at background of corrections and the law. I'm going to introduce you to American law, the corrections and the criminal justice system generally, the concept of habeas, torts, Section 1983 actions, and going to court. The law. It's really a set of principles and rules laid down to determine the rights and duties of a state or government citizens and to resolve disputes between those citizens. It's designed to give decisions binding legal force, and the courts are that voice of legal authority. Courts is one of the 3 branches of government. They tend to interpret and administer the law and determine the specific rights and duties of our citizens. It's mainly from English law. It relied primarily on decrees, orders, or writs, decisions of judges. Together, all that was referred to as the common law, still is. It's a part of our history and the formation of the U.S. Constitution, and the supreme law of the land is the U.S. Constitution. Even the Supreme Court gets its jurisdiction from the U.S. Constitution. Now, some of this is review, I'm sure. There's the branches of government are guided by 2 important principles: separation of powers and checks and balances. This textbook looks at the branches of government from a legal perspective. The legislature enacts the laws through statutes, executive enforces and carries out the law, and the judiciary, as we've been talking about, interprets and applies the laws. In the federal court system, the highest court obviously is the U.S. Supreme Court, and as I mentioned earlier, it's the only court established by the U.S. Constitution. The lower courts in the federal system are established by statute. It's the highest and final federal appellate court. There are 9 justices. They ordinarily accept cases by a writ of certiorari, and there's usually not that many cases that go directly to the U.S. Supreme Court. Those are controlled by the Constitution. Cases that do go to the Supreme Court, an example would be a case that would resolve a conflict between circuits. And based on this writ process, very few cases are actually accepted among all the cases each year. The trial court is the U.S. District Court. That's where you initially file a case, and there's at least 1 federal district in each state. There are multiple districts in Michigan. It's where the trial is held. It's where evidence is submitted. This is where the facts of the case are decided. The federal courts are most often a court of general jurisdiction, meaning they can handle both civil and criminal cases as well as equity type cases. most commercial matters that would go to the federal court system. The U.S. Court of Appeals, obviously, that's the appellate court system and the federal court system. They have jurisdiction over several states, referred to a circuit. Michigan is within the 6th Circuit. If you look in Chapter 1, Figure 1-1 on page 9 gives you a map that shows the breakdown of those federal judicial circuits in the United States. They accept appeals from the district court within their jurisdiction, and their job is to hear appeals, not to retry the facts of the case. Each party doesn't submit new evidence. Instead, they submit written briefs. There may be oral argument before the court. The decision or ruling is controlling within that circuit. The majority opinion is really the controlling law of the decision. It's commonly referred to as precedent in the circuit. And a dissenting opinion may also be issued. Criminal law is characterized by a higher standard of proof. You probably heard it referred to as beyond a reasonable doubt. It's higher than the civil law, and we'll look at some of the other distinctions in a minute. Crime is a violation of statute, either at the state or federal level, and the action is actually brought by the state official, prosecutor, on behalf of all the citizens of that state, or potentially a local county. And the penalty is different. A defendant faces a loss of freedom or liberty. There are felonies, which are ordinarily punishable by more than a year in prison. Misdemeanors ordinarily are a year or less. They're initiated, criminal actions are initiated by either an indictment or an information. And the case is brought by the state against the defendant who is charged with wrongdoing. So as we look at the difference between civil and criminal, in a criminal case, the prosecutor brings the action. Some jurisdictions also have what are referred to as petty offenses, or you might even hear terms like high court misdemeanor. Petty offenses are punishable only by fines or jail terms of 30 days or less. Civil law is sometimes referred to as private law. It focuses on the duties between people or between people against the state, but not. It's not like a prosecution by the state. The most common ones would be contract law, tort law, which we'll talk about more in detail. Contract law is promises between parties. Tort law would be more regarding an injury to some kind of interest somebody has either in their person or their property. Usually in a civil case, the remedy is money or some kind of equitable remedy like specific performance or injunctive relief, versus in a criminal case, it's the penalty is jail or prison. Civil actions initiated by an attorney with a complaint. The plaintiff is the party who brings the action, versus in a criminal case, it's the prosecution, and the defendant is the party who's charged with the wrongdoing. Some cases could be both criminal and civil, or there would be separate cases evolving out of the same action or transaction. An example might be assault, where there's a criminal charge for assault, but then that individual victim could bring an action against the defendant for a civil remedy like money damages. So I've mentioned most of these already. In a criminal case, the burden of proof is beyond a reasonable doubt. In a civil case, it's a preponderance of the evidence, which means more likely than not. Sometimes people say 51%. Most correctional litigation cases are civil, not criminal. Other categories are way and look at the law, case law, which is really another way of saying common law. Those are decisions of courts published in in law books. Statutory law comes from the legislature, either at the state level or federal level, and then administrative law. There's a large body of administrative law by administrative agencies. An example of a statutory law might be the Prison Litigation Reform Act or the ADA, Americans with Disability Act. Another category of law would be procedural law, the methods by which legal rights or duties are enforced. So this is kind of difficult. I like to think of substantive law as your rights and procedural law as the way you get your rights. So we'll talk about the right to an attorney. So constitutionally, you have a right to an attorney. That's substantive law. However, procedurally, how would you get that right to an attorney in a court proceeding? That's the procedural part of it. Let's look at Chapter 2, and that focuses on corrections and the criminal justice system. Corrections is part of the criminal justice system. Experts agree that there needs to be greater coordination between the different components of the criminal justice system. The legislature, they enact criminal laws and determine what the applicable sanctions would be for violating that law. And then the prison system can be impacted. Like an example would be a criminal get tough statute where it led to determining or terminating sentences, abolishing parole. The unintended consequence would be it would lessen the motivation of a prisoner, somebody who's really got no incentive to behave well or work towards release. And that, as a result, places an increased burden on prison officials to maintain the institutional security and good order. Looking at the rest of the chapter, we're going to define police, arrest, release, prosecutorial role, the court system, sentencing, and we talked a little bit about corrections already. The police's role is to prevent, detect, investigate crime, to apprehend offenders. It's done within the constraints, should be done within constraints of the Constitution and any statutory requirements. Most crimes aren't actually observed by police. They're reported to police. Many are not. And police do have significant discretion. And we'll talk about the prosecutor's role in taking those reports that are actually made, and then the police use their discretion to pass them forward to the prosecution, and the prosecution actually decides if they want to charge. A California Department of Corrections report regarding the disposition of adult felony arrests from back in 1997 shows that only 13% of persons arrested for felonies were sent to prison. And, that varies by state. It hasn't changed a whole lot. So, a lot of folks think that every crime is observed or reported and prosecuted, and that's not actually the case. Arrest would involve taking a person into custody, and that considerations around that are listed here. If somebody is arrested, they're booked. There's an entry into police records of information about the person and the crime. They're advised of their rights and given an opportunity to contact an attorney. And there's an opportunity in most cases for release on bail. Prosecution has a little different role. They obtain the results of the police investigation, information about the crime, statement of witnesses, other relevant evidence, and weigh that information really to determine if there's going to be an actual prosecution. When I was a prosecutor, I would get a police report with a request for a particular charge, and I would consider all the evidence, not just the evidence that was within that police report, and I might authorize that charge that was requested or perhaps a different charge based on the report and evidence is implicated, but I would charge crimes that I would be able to meet my burden of proving beyond a reasonable doubt, or at least in terms of my thinking. And, sometimes there was a tension between police and prosecution because of that. the police officer didn't always get exactly what they wanted to get charged. Prosecution in case of minor offenses, there's the complaint filed. It's usually taken to some lower court official, perhaps a magistrate. Their defendants advised of their rights. They give them a chance to enter a plea. If they don't enter a guilty plea and they request a trial, the trial date is set. If they're found guilty, penalties are imposed. Pretty straightforward. Usually these minor offenses are limited to fines or short jail sentences. More serious cases, higher misdemeanors or felonies, the prosecutor signs an information. In a felony case, there might be an indictment or grand jury or an information. Usually there's some kind of preliminary exam and things are bound over to circuit court if there's sufficient evidence. There's also defendants, again, is given their rights that they have, signing of counsel we talked about. Person would get a chance to enter a plea, get an attorney. They can make an election between a judge or jury trial. A court might actually dismiss the case based on insufficient evidence. Might also ask the attorneys to negotiate some other kind of resolution. Counsel has the responsibility to file motions based on things like a motion to suppress evidence of some kind, perhaps if it was illegally, unconstitutionally obtained. Defendants are entitled to their constitutional protections, and we'll go a little more detail about those. Under the 5th, 6th, and 14th Amendment, if the defendant pleads not guilty, then the case goes to trial, and as I mentioned earlier, that could be judge or jury, and that's the defendant's choice. Here are some of the constitutional safeguards or protections: the right to a speedy and public trial, impartial jury. They should be accused of something and get that information, but also have an opportunity to confront the witness who's accusing, obtaining witnesses, assistance of counsel, the 8th Amendment, prohibition against cruel and unusual punishment, the constitutional safeguard regarding equal protection of the law, guarantee of due process. It's interesting, the Constitution says no deprivation of life, liberty, or property without due process. It doesn't say the government can't deprive you of life, liberty, or property. It just says you can't do it without due process of law. If there is a guilty plea or there's conviction, then there's sentencing. This is a judicial process that only the courts can impose as authorized by criminal statute. Those sentencings might be legislatively mandated by guidelines, statutory guidelines, and there might be some situations that exist that mitigate or even aggravate that would allow the judge to go below or above what the sentencing guidelines suggest. The objective is to try to fit the sentence to that particular defendant, perhaps based on their prior convictions or whatever the circumstances were. The idea of imprisoning somebody would be to prevent them from doing additional harm, to deter them, or to potentially rehabilitate them. In the pre-sentence investigation report plays an important role in the court's decision regarding sentencing. It gives information about the offense, the criminal conduct of the defendant, their background. If you look in Appendix 1, back on page 517, there's a good example of a pre-sentence report. Corrections, the last component of the criminal justice system we'll talk about. This would include probation, parole, jails, community corrections, prisons. Sentencing could range from everything from fines, restitution, which wouldn't involve jail or imprisonment. Also could involve probation supervision, suspended sentences, and then on the other end of the spectrum, everything up to execution. So this is corrections is a broad area. In the case of probation, a defendant doesn't go to prison. Instead, they remain in the community under some kind of supervision. Typically, a defendant must follow the probation conditions. Usually there's standard conditions like not using drugs. And there's also specific individual conditions based on, background of that defendant or circumstances. And payment of restitution is usually part of that. If you look at Appendix 2, page 539, it lists some of the mandatory, standard, special, other conditions that can be posed on a person. Probation officers have a caseload, and it can vary in terms of how many and the degree of supervision. Unsupervised probation would be minimal supervision. Intensive probation would be frequent contacts. At the end of 2002, there were almost 4 million people on probation. These are kind of old statistics, but back in 2001, the average regular caseload for probation officer was 127, and that's increased substantially these days. It's really important to distinguish the difference between probation, which is a judicial function, and parole, which is an administrative function, where the paroling authority allows the person's release from prison. Could be circumstances involving a fine, which this could be imposed of instead of or maybe in addition to confinement. It's usually for lower level offenses like traffic offenses, and in those type of cases that fine might be an accepted method of punishment. Fines are fairly easy to fit into sentencing processes, they're fairly easy to administer. However, they may not be available for indigent offenders, and fines might not be seen as overly punitive. Restitution is a term that refers to getting a victim their money back for injuries that they suffered, making them whole. Courts could order the defendant to make restitution to the victim for direct damages or loss or things indirectly related to the offense. The difficulty of restitution concerns some conflicting directives. The states may give victims the right to restitution, but may fail to require a court order the sanction. It's also difficult to calculate the amount of loss in some cases, or there's also the reality of the defendant's inability to pay. And then electronic monitoring is something that's more common these days, involving some kind of bracelet or anklet worn by the defendant, transmitting through some connection, electronic connection, to let somebody who's monitoring know where a defendant is. And even more recent ideas of community service and creative sentencing. Sometimes people say the focus of this is more on teaching a lesson to the offender. For example, serving in the community for a drunk driving conviction, talking to a high school student about the dangers. So this kind of gives you a range of the idea of what's covered under corrections and some of the sentencing, ranging from simple imprisonment to creative sentencing. Feel free to email me at gbrand@grcc.edu if you have any questions.